To give us an in-depth look into this event, we have here today Dr. Phạm Lan Dung, Director General of the Foreign Service Training Center under the Diplomatic Academy of Vietnam. Thank you for taking your time with us. The first question, many observers, when they heard about the case, they wonder how the Philippines could unilaterally file a case against China to an international arbitration court, because these kinds of cases usually require the participation of both sides. But China stated that it did not accept the jurisdiction of the arbitral tribunal. So what mechanism of international laws allows this to happen?
The United Nations Convention on the Law of the Sea provides for a compulsory dispute settlement system in accordance with which a party may unilaterally bring a case before a judicial body. UNCLOS, however, allows party to exclude from compulsory jurisdiction certain categories of disputes related to maritime delimitation, sovereignty, historic base, historic titles, etc. The crucial point here is, if there is a dispute over the tribunal jurisdiction, it is the tribunal itself that has the final power to give the decision on the question. In the case between the Philippines and China, the arbitration examined carefully the question of jurisdiction and decided that it has jurisdiction on certain issues of the case, such as the status of the features, whether the features have the status of islands or rocks or only low tide elevations. The arbitration may also find its jurisdiction on the question of the illegality of the U-shaped line under UNCLOS. If the U-shaped line is found to be illegal, that would similarly reduce the overlapping areas, especially those from the excessive claims of China.
So how will the award of the tribunal be enforced after being delivered on July 12th?
In accordance with the Convention on the Law of the Sea, the decisions of the arbitration is final and binding upon the parties. Since both China and the Philippines are parties to UNCLOS, they are under the obligation to fulfill the provisions of the conventions. Therefore, they are also under the obligation to comply with the award of the arbitration. The enforcement of the arbitration award relies on the general principles of international law, Pacta sunt servanda, which means the goodwill of the party to fulfill with the obligations in international treaties. It also relies on the so-called public opinions from countries, international organizations, and other entities in the form of blaming and shaming. There is no specific mechanisms to enforce arbitration award. However, parties to UNCLOS and other countries may have the right to enforce the award themselves. Countries may choose diplomatic means or economic or political means and other means, provided that they are in accordance with international law. A country may deny jurisdiction of a tribunal and may not participate in the case. However, once the judgment, the award is delivered, it is final and binding. Non-compliance with the award of arbitration is an act in violations of international law.
Once again, thank you very much for joining this interview.